High Court in Pretoria has ruled sections of the Health Act unconstitutional, affecting the National Health Insurance's requirement for the Health Department to issue a certificate of need. 8 applicants, including Solidarity, the Alliance of South African Independent Practitioner Associations, the South African Private Practitioner Forum and the Hospital Association of South Africa, successfully challenged the certificates of validity. For more on this, we now speak to Minister of Health, Dr. Aaron Motsoaledi, for his reaction when it comes to that court ruling. Minister, thank you so much for your time this evening. For the benefit of our viewers, we've seen your statement. Let's start off with your reaction. You've noted how disappointed you are when it comes to this court ruling.
Yes, of course. I said so. 2 disappointments, Mbali. Firstly, the court ruling and the manner in which the judgment is based solely and mostly on property rights, whereas we're dealing with health issues. And secondly, the manner in which the media reported it as a big blow to NHI, and even saying NHI cannot go on without those sections of the Act, when actually that is not so, because the sections of the Act that were declared unconstitutional were sections of the National Health Act 61 of 2003. And you are aware that NHI is a new act which was passed in 2023. So the ones that were declared unconstitutional are of the National Health Act. And there's a further claim that because those have been declared unconstitutional, NHI won't go on.
Yeah.
Or NHI, it won't happen. And that's exactly what concerned me, because that's not true.
Minister, maybe then clarify then, what then does this mean for NHI? Because, you are saying that to even include NHI, is what you are saying is misleading. What does this ruling then mean for NHI?
The court case was not about NHI, Bali. It was about Section 36 to 40 of the National Health Act passed in 2003. The actions against NHI up to now are 2. And they've submitted the documents. The court have not yet decided even on the date of hearing the cases against NHI. So this case was not about NHI, It was about the National Health Act. That's what I'm saying. And secondly, I am saying it does not mean because the court has declared these sections unconstitutional, it does not mean NHI cannot go on unless the court declares NHI itself unconstitutional. And up to so far, that has not yet happened.
So basically meaning then, for the NHI to go ahead, this will then not affect NHI in our country?
Well, Mbali, let's maybe the other confusion is we've got the different versions or permutations or, different perceptions of what NHI is all about. NHI is a health funding, is health funding, is universal health coverage. It's about health funding, such that when people are sick, they are financially covered. They are not forced to look for health care by selling their property or their savings, etc. They are able to be helped, like me and you. I'm saying me and you because I do suspect, because you are waiting for SABC, you have got the medical aid, which is actually being subsidized by SABC through the state. I am also a member of parliament. I've got a medical aid. I'm being subsidized. When my children are sick, or I am sick, or you too, when you are sick, you don't panic. You just go to the nearest best facility and you produce a medical aid. Other South Africans are not able to do so. In fact, extraordinary majority of South Africans are not able to do that. If they have to do that, they pay exorbitant sums of money by selling their livestock, selling their policies, sometimes even mortgaging their houses. Now, NHI is a healthcare finance system whereby you will be financially covered for your illness, regardless of your financial status. and that is the catchword, regardless of your financial status, because those who are on medical aid and are being subsidized are only 14% of the population. 86% is not covered, and NHI wants to bring that to an end. It's an equalizer between the rich and the poor, whereas the section that they've been declared unconstitutional are about a register of need, which deals with two things. Number one, the facility which you want to provide health in, is it of good quality? Does it reach certain agreed upon standards? That's number one. Number two, is that facility, are you wishing to put that facility in an area where there is need, or you just want to follow the others because you saw them all going to Santen and say there's a lot of money, you just go there even if they need this elsewhere? That's basically what the certificate of need is all about.
Yeah.
NHI is about the financing. The certificate of need is about where facilities are situated.
As a department, will you be challenging this outcomes from the courts?
Mbali, this court declared sections of an act unconstitutional. By law, when a law has been declared unconstitutional, the whole of it or sections of it, it has to be confirmed by the Constitutional Court. That in itself works more or less like an appeal, because you can be heard about, you can put up your facts in front of the Constitutional Court. So that whether we like it or not, it is going to the Constitutional Court anyway, where the Constitutional Court will either confirm it or reject it, and will take the matter from there. As to whether we can appeal, we are not stopped from appealing, but we are still thinking about it. But whether we appeal or not, it is still heading to the Constitutional Court.
All right, Minister, thank you so much for that clarity from your end when it comes to that court ruling we saw earlier on in the week. That's the Minister of Health, Dr. Aaron Motsoaledi.